Good morning to all of you who've already joined in. We're going to allow just a few more minutes for everybody to get logged on. Good morning, everyone. We're going to go ahead and get started with our presentation now. My name is Cynthia Lofton. I'm an operations manager with the Bankruptcy Court. On behalf of myself, the presenters, and the rest of the staff, we would like to welcome each of you to our annual ECF Filing Procedure Seminar. Please know how much we appreciate you taking time out of your busy schedules to attend this seminar. We have conducted several seminars over the years. However, this is our first experience presenting a seminar via Zoom. So our hope is that everything goes smoothly and that we are able to provide you with some valuable information today, as well as answer any questions you may have. Our agenda for today: first, the introductions, online resources, ECF account management. And for those of you that don't know, ECF stands for electronic case filing, filing of documents, and then we'll cover common filings by creditors. At some point this morning, we'll take a break and give y'all a time to break and us as well. So we really want to hear from you today. If you have questions, concerns, comments, please submit them to us by selecting the Q&A option at the bottom of your screen, and we will cover the questions at the end of each respective session. If for some reason we can't answer, we will definitely answer you before we end the presentation. To the court's disclaimer, just a note that the information being provided to you today is for informational purposes only and does not constitute legal advice. This is a snapshot of the management team for the Bankruptcy Clerk's Office, Southern District of Mississippi. Our Clerk of Court, Danny Miller, Chief Deputy, Colette Derwin, Cynthia Lofton, Operations Manager, Katie Wise, Operations Manager, Keisha Moore, Operations Manager, and Josette Dutil, Operations Manager. Your presenters for today: again, my name is Cynthia Lofton. I'm an Operations Manager in the Jackson office. I've been employed at the Bankruptcy Court since 1991. Your next presenter will be Katie Wise. Katie is an Operations Manager in the Gulfport office and was employed in 2000. Following Katie will be Keisha. Keisha is an Operations Manager in the Jackson office and was employed in 1998. Your next presenter will be Summer Wiest. Summer is a case administrator in the Gulfport office and was employed in 2017. Summer is backup to Judge Stampson's courtroom deputy. She conducts ECF online training and manages a full caseload. Next, we have Alexis Bradley. Alexis is also a case administrator in the Gulfport office. Alexis manages a full caseload, processes Chapter 11 cases, and conducts online ECF training. Alexis came to the court in 2018. Josette Dutil, our navigator for today, has been employed since 1997, and she is an operations manager in the Gulfport office. So I say all of this just so that you can see what you have available to you today, people with years of experience and a wealth of knowledge. So with that being said, I will now turn the presentation over to Katie, who will begin by discussing online legal and procedural resources. And again, we thank you for your time and attendance. Katie?
Thank you, Cynthia. Good morning, everyone. As Cynthia stated, I am Katie Wise, and I'm an operations manager in the Gulfport office. The first topic I will be covering is online resources. Online resources can be found on the court's website under www.mssb.uscourts.gov. As Cynthia stated, if you have any questions during the portion of the presentation, please use the Q&A option, and I will do the best I can to answer it at the end of the session. To find the court's contact information, click About the Court on the home page banner, then click Contact Information to find information for chamber staff, case administrators, and the clerk's office. To find the case administrator assigned to a particular case, you would click on the Case Administrators for Chapter 7 and 13 link. Cases are assigned by the last two digits of the case number. The assigned case administrator's phone number is in the second column across from the digit set. You can call their direct line or the office's main line for assistance. The contact information page also contains links for the for chambers, Chapter 11 and adversary case administrators, office locations, and communication disabilities coordinator. Please note that the new mailing address for the Jackson office is the street address. The court will no longer receive mail at the P.O. box. On the homepage, under the Rules, Orders, Procedures tab, you will find the local rules, standing orders, administrative procedures for electronic filing, ECF docketing guide, e-order attorney guide, emergency filing procedures, procedural videos, presumptive interest rate, restrictions for cell phones and other electronic devices, transcripts, audio recordings, and the bankruptcy federal rules. For emergency filings, when the system is unavailable and it is necessary for a filing to be made, there are procedures to follow that is posted on the court's website under the Rules, Orders, Procedures tab. If it is during the regular business hours, please call the clerk's office and speak with an operations manager. And if it is after hours, you will call the court's emergency line. The emergency number is managed by a court staff. It's an actual person. The person answering the call will make arrangements to accept the filing, and the filing will be effective upon the receipt by the court staff. Okay, on to the next topic, court notices. Let's talk about how the creditors receive court notices. Creditors receive court notices and documents at the address that the debtor lists in their schedules, unless the creditor provides a different noticing address on the proof of claim form or registers for electronic notices with the BNC. You can sign up on the BNC website to receive all of the bankruptcy notices electronically or U.S. mail at one address. Electronic bankruptcy noticing, or EBN for short, is reliable, more efficient, and free. It's a free service that allows court notices to be transmitted electronically, delivering them faster and more conveniently. Some individuals or entities are required to receive notices through EBN. Rule 9036 requires all parties that receive 25 or more paper notices in a calendar month must register for EBN. If the party does not register for the BNC, the BNC will send future notices to an email created by the director of the AO. All right, I'm going to review the Q&A box to see if there's any questions. There seems to be none, but I'll give it a few seconds just to see if anybody pops up. Okay, I have a question saying the 25 notices, is that per court or nationwide? I believe that is nationwide. But I will find that out for you and get you a direct answer, but I believe it is nationwide. The emergency filing after hours. Does the debtor get to file a case after closing? Only if it is an emergency filing and they contact us. Then, yes, if it is a case, they can file after hours. Okay, hold on, let me. What is considered an emergency filing? That's a broad, I mean, let's say if they're trying to stop a foreclosure, a repossession, a garnishment, and if for some reason their attorney cannot use the system to file, say that the system is down, that is why that is after hours and they could call us. Now, we do have 24/7 filing with the CMECF and they can file it anytime. But if there's the emergency issue, the emergency line, that is only if they cannot file it electronically. Something's wrong with the system, and they do have an emergency filing that they have to get done ASAP. Will you back up to the BNC information to sign up for electronic info? Josette, if you can go back to, I think it's slide 17. Also, we are going to put this PowerPoint on our website. So all of this, if you've missed something or anything like that. Pete, does that help you? Okay, he said yes. Okay. Hold on just a second. We gotta get everything. Will the PowerPoint be under the resources tab? It's usually on our home page. Like as soon as you log in, you'll see the PowerPoint. Okay, let's move on. Okay, let's talk about forms, specifically fillable and our local forms. When using PDF fillable forms for filing through CMECF, the user must lock or flatten the PDF document after completing the form fields to ensure the document can be viewed on all electronic devices and to prevent others from editing the information. The court provides many local forms. The forms are located on the court's website. Simply click the Bankruptcy Forms Fees on the homepage banner and then the local forms. This is a screenshot of some of the local forms. Several are in fillable format for your use and are notated as such. Is there any questions? Let's see if there's any questions in the Q&A box regarding the forms. And I'll wait just a second. Okay, it appears there is no question, so let's move on. Let's talk about the ECF docketing guide. Again, if you have any questions, please use the Q&A option and they will be answered at the end of the session. The ECF docketing guide is interactive and provides filing guidelines. The guide is located on the court's website. On the homepage banner, click the Electronic Case Filing tab. Then on the left-hand side of the page, you would select ECF Docketing Guide. The guide's welcome page will open, and you can view the court's contact information here as well from this page by clicking the Click Here link. Clicking the link redirects you to the court's contact information page on our website. On to navigating the guide. Where the navigation options appear depends on the size of the monitor or the web browser. On this screenshot, the options are on the left. The first option is the table of contents. The second option is the glossary. And the last option is the search feature. You will select the table of contents to navigate by the topics listed. Main topics are represented by a circle with a plus sign. Each main topic has additional topics under them. For example, when you select the plus sign next to amendments, the table of contents expands, displaying topics on amendments. The glossary is a list of terms within the guide. You can click on a term from the list or start typing in the filter field to view terms in the glossary. To view the definition, click on the term. The search option is the fastest way to find information. To search by term, type a keyword in the search field and hit enter. The screen displays all topics that contain that keyword. If we go back to the table of contents and click on docket event list, you will see that it has 3 subtopics. You see the event list for adversary, bankruptcy, and limited filer. Each subtopic provides a list of docket events for that subtopic. For example, when you click on the limited filer event list, which are the events used by non-attorney creditors, it reveals the list. An event that is underlined or is in blue or purple is a link to that topic related to the event. For example, when you click on Notice of Change of Address from the list of events, the topic displays. You may be asking yourself, how often does the court update the user guide? Well, it depends. It depends on updates to our office procedures or amendments to the rules that may require revising. For major updates, the court will send an email announcement and post information on the court's website, Facebook, and Twitter accounts. To view updates to the guide from the table of contents, click on Updates, ECF Docketing Guide. A list of the most recent revisions will display. Any questions? Let's see if we have any in the Q&A box. And I'll give it a few seconds because it doesn't appear that there is any right now. Okay, now I'm going to hand it over to Keisha to cover the unclaimed funds portion of this presentation. Keisha?
Thanks, Katie. As previously mentioned, my name is Keisha, and I will cover unclaimed funds. Most money held by the U.S. Treasury is unclaimed funds, which are deposited into the Treasury by the case trustee at the end of a case. Some of the reasons funds go unclaimed are: the recipient never received the check due to a bad mailing address, the check is not cashed within 60 days after the trustee disperses the money, or the recipient is deceased. For these reasons, unclaimed funds are held indefinitely for the claim owner. There is a tool on the court's website that gives the public access to unlimited funds across the nation. The locator allows a person to search for money that is owed to individuals, businesses, and government units. Go to the court's website, www.mssb.uscourts.gov, and hover over the Case Information tab. When the menu opens, select the Unclaimed Funds Locator link. You can search by a specific court or all courts, creditor name, debtor name, case number, date of deposit with the court, and please note you must enter the CAPTCHA code and at least the first 3 letters of either the creditor's name or the debtor's name to search the database. To request payment of unclaimed funds, the requirements are a notarized application, which is local form MSSB-1340 with a certificate of service, a proposed order granting the application, which is local form MSSB-1340 order, supporting documentation, and service to the U.S. Attorney for the Southern District of Mississippi. Now, let's look at the terms claimant and applicant. A claimant is the person who claims to be the owner of the funds. An applicant is the individual that signed the application, and many times the claimant and the applicant are the same individual. Who can request unclaimed funds? An application to release funds can be filed by the owner, a successor claimant, or another type of claimant. The process for applying for unclaimed funds is an administrative function. Therefore, a business or corporate claimant does not need to be represented by an attorney. As there is no requirement that the case be opened, a claimant may file an application to release unclaimed funds in a closed case. Let's discuss types of authorized claimants. The owner of record is the person or entity the court records show the money is owed. Requirements for an individual claimant are a legible copy of a photo ID, such as a driver's license with current name and address, documentation of any former address as provided on the transmittal of record, and if the claimant's name has changed, documentation supporting the name change must be provided, documentation such as a former driver's license, and tax ID information such as an AO 213P form or an IRS Form W-9. Requirements for business claimants are the representative for the business must sign the application. There must be a notarized statement of the signing applicant's authority, a legible copy of a photo ID such as a driver's license, other state-issued ID, or U.S. passport, and documentation supporting name change for the record of owner, such as a former driver's license. A successor claimant can be an individual or business that has a claim to the money but are not owners of record. Examples of successor claimants are a successor business, an individual's estate, heir, assignee, or a judgment creditor. Requirements for an individual successor claimant are a copy of a driver's license or other state-issued ID or a U.S. passport, and documentation sufficient to establish chain of ownership or a transfer of claim. Requirements for a business successor claimant are an application signed by the authorized representative for the business, a copy of a driver's license or other state-issued ID or passport of the applicant, a notarized statement of the applicant's authority, a notarized power of attorney signed by an authorized representative, and documentation sufficient to establish chain of ownership or transfer of claim. The requirements for a deceased claimant's estate are a copy of the representative's driver's license or other state-issued ID or U.S. passport, certified probate documents or other documentation authorizing the representative to act on behalf of the estate, and documentation sufficient to establish the deceased claimant's identity and right to the funds. An other claimant is a party that proves they are entitled to the money. Generally, this is a funds locator acting for the owner. This can be done by power of attorney or by assignment of a claim. The requirements are a copy of the representative's driver's license or other state-issued ID or U.S. passport, a notarized power of attorney signed by the claimant or claimant's representative, and documentation sufficient to establish the deceased claimant's identity and right to the funds. The requirements to request unclaimed funds are file an application using the court's local form, have it notarized, attach a certificate of service, and send a copy to the United States Attorney for the Southern District of Mississippi. The application, order, and instructions are located on the court's local forms page. The instructions contained detailed information on the requirements for submitting supporting documentation. You should file the application using the event Release Unclaimed Funds from Court Registry in paren application under the Claims Actions menu. For the proposed order granting the application, file the proposed order granting the application as an attachment. And please do not include any supporting documents at this time. The event to file supporting documents restricts public access to the PDF because of the personal identifiers included in the documents. The supporting documents should be filed as one PDF using the event Claims Actions, Supporting Documents, RAY, Unclaimed Funds, and in paren, it'll say Document Restricted. The clerk's office generally processes the paperwork necessary to release the funds to the claimant 28 days after the court enters the order granting the application. We normally disperse funds by treasury check. Because of fraudulent applications, we rarely disperse unclaimed funds electronically or by EFT. Let me check the Q&A section for questions on unclaimed funds. There do not appear to be any. So now I will turn things over to Summer.
Thank you, Keisha. Now we will go over electronic case filing system account management. It is very important to keep all contact information up to date to avoid missing pertinent information from the court. The registered user is responsible for maintaining their ECF account information. The clerk's office does not have editing access to filers' account information. Ownership of the ECF account belongs to the individual and not the company. An ECF account cannot be shared or transferred to another person. The ECF user name may not be changed to a business entity. And remember that the ECF user's login credentials serve as the filer's signature on the document. We want to stress that the ECF user must protect and secure their PACER username and password, and accounts must not be shared with another individual. And the ECF user is responsible for all documents filed and fees incurred with their ECF account. Contact information such as name, address, phone number, and primary email address for the ECF user can only be updated through their PACER account. The filer updates the contact information by logging into their PACER account and under My Account and Billing, select Manage My Account Login. Click the Maintenance tab. On the Maintenance page, the Update Personal Information link allows the ECF user to update their name, prefix, and suffix. The Update Address Information link allows a user to update the name of the firm, user's address, and phone number. The Update eFile Email Noticing and Frequency link allows the user to update their primary email address and delivery method, meaning they get Notice of Electronic Filings, or NEFs, for each filing, or a summary of all filings at the end of the day. This link does not let the user add or update secondary email addresses on their ECF user account. We will go over that process in a little while. To update the ECF user's account address, update firm name, address, and/or phone number, enter the reason for the update or change, select which case to apply the changes to, select the court to apply the update, and click Submit to send the update request. To update the email address, check the box for the courts you would like the changes to be applied to. Update the primary email and confirm the email. Select the frequency and format, and click Submit to submit the update. Let's see if there are any questions in the Q&A box. I will give it just a few seconds to see if any appear. Okay, there appear to be no questions, so we'll move on to the next topic. Filing documents in CM ECF. It is important to make sure all filing requirements are met. The standard page size for all documents, including your attachments, is 8.5 by 11. The ECF system will not accept a PDF document with one or more pages exceeding the standard size limit. ECF users must pay all filing fees for ECF transactions through their PACER account. PACER accepts Visa, MasterCard, American Express, Discover, Debit Visa, Debit MasterCard, and ACH payments via checking and savings account. Filing fees must be paid the same day the transaction is submitted. If fees are not paid by midnight, the system will automatically lock the user's account, preventing viewing and filing until the outstanding balance is paid. And all personal identifiers, including but not limited to Social Security number, tax identification number, financial account numbers like bank accounts, credit card numbers, loan numbers, dates of birth, names of minor children, and criminal cases that include home addresses must be redacted. Let's talk more about PDFs. The ECF system only accepts PDF format. All PDF documents must be locked or flattened before they are uploaded in the court's ECF filing system. Flattening ensures that a document can be viewed on all devices and prevents a user from saving a document offline and editing the information. Now we'll go over saving a Word document as a flattened PDF file. The easiest and most reliable method to convert a Word document to a flattened PDF document is to save using a PDF printer option. In Word, click on File, click on Print, and select Microsoft Print to PDF. Name and save the file, and then you have a saved flattened PDF ready to file. Now, the court also provides many official and local forms that are fillable PDF forms. And to flatten these fillable forms, the easiest way is still to save the form using a PDF printer. It is the same method we just used to save our Word document as a flattened PDF. So the steps to flatten a PDF fillable form is to open the fillable form, add the appropriate data, click File from the main toolbar, and click Print to select a printer. The print window will open, and from the printer drop-down menu, select the PDF printer. In this example, we are selecting Microsoft Print to PDF. Click Print, and specify a location to save the flattened version of the form. Add a file name and click Save to save the flattened form. Then you're ready to file that flattened form in CM ECF. And just FYI, the Adobe PDF printer is installed automatically with Adobe Acrobat, but there are numerous free PDF printer drivers available for download from the internet. The left image is a flattened and secure document. And notice the blue boxes on the right image, which indicate the form is fillable and not secure. We'll take a moment to see if there are any questions from the Q&A box. And I will give it a few seconds to see if y'all have any. Okay, there appear to be no questions at this time, so we will move on. Now we will talk about docket events. One option to find an event is to use the search option located on the main menu bar. Click Search from the main menu bar and enter a word or term in the search field. The search results will provide the main menu item to find the event. In this example, the menu item is Claim Actions. Below the menu item, any docket event that has the term that you searched will be reflected as a blue hyperlink. To select the event to file the document, you simply click the appropriate blue hyperlink event. The system will prompt you to enter the case number and bring you to the screen for selecting events. Notice the event is pre-selected for you, so you simply click Next to continue. Are there any questions at this time about docket events or any thing that we've covered so far? Okay, we will move on. Our next topic is personal identifiers and privacy protection for filings made with the court, which is governed by the Federal Rules of Bankruptcy Procedure 9037. Personal identifiers listed on documents and attachments may only include the last 4 digits of the Social Security number and tax identification number, the last 4 digits of the financial account number, the year of the individual's birth, and the minor's initials. The clerk is not required to review documents filed with the court for compliance with this rule, as Subdivision A recognizes the responsibility to redact filings rests solely with counsel, parties, and others who make filings with the court. To redact information on a previously filed document, a court order is required. Therefore, because corporations, meaning non-individual parties, must be represented by an attorney in litigation before the court, the creditor must hire counsel to file the motion to redact. And next, we're going to discuss certificates of service. Common documents that require certificates of service include creditor's request for notice, notices such as notice of change of address, notice of mortgage payment change, notice of post-petition mortgage fees, expenses, and charges, and notice of withdrawal of proof of claim, and responses to notice of final cure payment, Rule 3002.1. The certificate of service must include the name of the party served, the method of service, and the filer's name and signature. This example shows the filer serving a party via regular mail because the party is not designated or able to receive NEFs from the ECF system, but are nevertheless entitled to be noticed of said pleading or document. This example shows service of a party that is designated or able to receive those NEFs, those notices of electronic filing, through the ECF system. When the certificate of service is attached to a pleading, make sure the certificate of service has a title. It should reflect the party served via regular mail and the party served via ECF. And last, the certificate of service should have the signature of the filer. When a certificate of service is filed alone, for example, if it's left off the original entry, it is required to have the case caption at the top, a title, the parties served by a regular mail, the parties served by ECF, and the date and signature of the filer. At this time, we are going to take a short break. So we'll give you about 15 minutes in case you need to just have a short break. So if you'll be back at 10:02, we will continue the session. We are going to allow a few seconds to make sure everyone has a chance to make it back. Welcome back, everyone. Now I will hand things over to Alexis for our next topic.
Thank you, Summer. My name is Alexis, and we will discuss some common filings by limited filers. The most common filing is a proof of claim. The requirements for filing a proof of claim includes official form B-410 and any supporting documents. You must be sure to redact or leave out information entitled to privacy on the proof of claim form and any attachments included. When a proof of claim form is filed, the creditor essentially is requesting that all relevant notices be sent to the address listed on that claim form. It is important to understand that the address provided on the proof of claim takes precedence over any previous address listed in the schedules or the list of creditors. This means that once a proof of claim is filed with a new address, that address will be used for all future communications related to that claim. To file a claim, you must first log in to ECF and from the menu bar, select Bankruptcy, File Claim, and enter the case number. And leave the name and creditor type, the creditor and type of creditor field blank. Next, you will use the drop-down to select your creditor. If the creditor does not match exactly what is listed on the claim form in regards to the name and notice and address, you must select Add Creditor. This is an example of Part 1 of the proof of claim form. On Section 1, you enter the name of the claim owner. That is the creditor that receives payment for the claim. On section 3, you would need to enter the address where the claim owner is to receive notices. Remember, this address will replace any previous address provided by the debtor in the schedules. When the name of the company to receive notices is not the claim owner, as in this example, the creditor is HSBC Bank USA, and the company to receive notices is PHH Mortgage Corporation. You would need to enter the creditor's name from section 1 and then the name and address provided in section 3. Now we will cover amended proof of claims. Just for clarification, if you fail to attach the official proof of claim form with the original filing, please call the clerk's office for instructions on how to correct. You cannot amend that entry by filing an amended proof of claim, as it will be notated as a docketing error. The requirements for amending a proof of claim are official form B-410 and any supporting documents. To file the claim, you will select bankruptcy and then file claims. A claim should not be amended to change the claim owner. To change a claim owner, a transfer of claim must be filed with the court. Also, a claim should not be amended to change the notice or payment address. A change of address form would need to be filed in the case. You would need to know the claim number for the claim that is being amended. If you don't know, you should review the claims register through PACER. So complete the form and make sure on line 4 that the yes box is checked. You would need to enter the claim number being amended and the date it was filed. During the docketing process, you must select the creditor. It should be the same creditor that filed the claim that you are amending. To locate the previous claim filed, you will type in the claim number in the amends claim number box and select Find. On this screen, select the name of the claim being amended. The creditor filing the amended claim should be the same creditor who filed the previous claim. Next, we will discuss withdrawing a proof of claim. A creditor may withdraw a claim by filing a notice to withdraw proof of claim, except for when a party objects to the claim, if a party files an adversary proceeding against that creditor, or if a creditor accepted or rejected the plan or significantly participated in the case. The requirements include a withdrawal of claim and certificate of service. We do not have an official or local form for withdrawal of claim. The filer must draft that document on their own. And to file the withdrawal, you will select bankruptcy, claim actions, and search for withdrawal of claim. So let's review the Q&A box to see if we have any questions. And I'll give it just a few seconds in case someone's typing. Okay, so now we will move on. And we will discuss transfer of claims. Generally, a creditor files a transfer of claim when they purchase a debt from another creditor. The transferee is the buyer and the transferor is the seller. There are 2 filing options. One is when the transfer includes a waiver of notice signed by the claim owner. Generally, a written waiver of notice is attached as well as a proof of the purchase. The other option is when a notice of waiver is not included with the transfer document. The requirements to file a transfer of claim with the waiver include the official form B-2100A with the signed waiver by the transferor as an attachment, along with the $28 filing fee. To file this document, select bankruptcy, claim actions, and search for transfer of claim with waiver of notice. The requirements to file a transfer of claim without the waiver include the official form B-2100A along with the $28 filing fee. To file this document, select bankruptcy, claim actions, and search for transfer of claim, no waiver. For the transfer of claim without the waiver, the clerk will provide notice of the transfer, and the transferor will have 21 days to file any responses or objections. If no response is filed, the transferee will become the new claim owner, and if a response is filed, a hearing will be set. Okay, let's see if we have any questions regarding transfer of claims. Just a few seconds. Okay, I do not see anything, so we will move on. Next, we will discuss the notice of mortgage payment change. In a Chapter 13 case, the creditor must file a notice of mortgage payment change, providing any change that results from an interest rate or escrow account adjustment. The creditor must give notice of the change within 21 days before the new payment becomes due. The requirement for filing the notice includes the official form 410S1 and a certificate of service. If there is a proof of claim on file for the creditor, you would need to use the docket event notice of mortgage payment change. If there is no proof of claim on file, use the docket event notice of mortgage payment change, no proof of claim filed. If you fail to attach a certificate of service, you must file the certificate as a separate document by selecting Bankruptcy, Claim Actions, and search for a certificate of service used only for Rule 3002.1 events. Okay, let's see if we have any questions regarding mortgage payment changes. Yes, so we do have a question. Where can I view this webinar later? So we will make this available on our YouTube channel, which can be located through our court's website. It may not be available right after, so I would give it about a week or so, but it will be available on our website. Okay. Let's move on. Okay, so now we will discuss filing a creditor's request for notices. A request for notices under Bankruptcy Rule 2002 can be made by a creditor or party in interest for the purpose of ensuring that they receive all notices required to be mailed under Bankruptcy Rule 2002. Subdivision G recognizes that an agent authorized to receive notices for a creditor designate where notices to the creditor should be addressed. Filing a proof of claim is considered a request designating a mailing address. Subdivision G has been revised to clarify that where a creditor or indenture trustee files both a proof of claim, which includes a mailing address, and a separate request designated a mailing address, the last paper file determines the proper address. The requirements for filing a creditor's request for notices include The requirements for filing a creditor's request for notices include the request for the notice, and there is no official or local form. You must draft the document along with a certificate of service. To file your request, select Bankruptcy, Claim Actions, and search for creditor's request for notices. To have the party's name and address correctly entered into the system, be sure to put the creditor's name only on the first line. And if there is a servicer, the servicer information should be on the next line as shown in this example. Additionally, do not reference any account information, only include the creditor's name and address information. Let's check the box to see if we have any questions. All right. Oh, sorry, we had one question come in, so let me review it really quick. Can a notice be filed by a limited filer from out of state? Like a creditor's notice for, let's see, the request for notice, yes. But you would have to be a filer with the court to be able to file the creditor's request for notices. If that answers your question. Okay, so for the next topic, we will cover the change of address. The requirement for filing a change of address is a notice of change of address for a creditor. And we do have a local form. It's MSSB-NCAC. To file the notice, you would select bankruptcy, claim actions, and search for notice of change of address. We recently created a fillable form available on our court's website. Input the name of the creditor. You would need to list a current address as it is listed on the case. Input the new address for where notices should be sent. Enter the information for the new address where payments are to be sent. Input the proof of claim number. Select or list the reason for the change. And input the information as the filer. And make sure to complete the information for the certificate of service. Okay, let's again review the Q&A to see if we have any questions. And I'll give it just a few seconds. Okay. So now we will discuss reaffirmation agreements. A reaffirmation agreement is a written agreement between the debtor and a creditor in which the debtor agrees to pay a dischargeable debt. In order to enforce the reaffirmation agreement, you must be sure that the agreement is made prior to the debtor receiving a discharge and filed with the court. The agreement must not be rescinded before discharge or within 60 days after the filing of the agreement with the court. A reaffirmation agreement can be filed by either the debtor or creditor and must be filed within 60 days after the meeting of creditors. The requirements for filing a reaffirmation, if the debtor is represented by counsel, includes the reaffirmation agreement and cover sheet. If a debtor is not represented by an attorney during the negotiation process, the agreement will not go into effect unless the court approves it, unless the agreement is for consumer debt secured by real property. The requirements for when a debtor is not represented by counsel is a reaffirmation, the cover sheet, and a motion for approval. There are two official forms located on our court's website, Form 2400A and Form 2400A/B ALT, which includes a motion for approval. To file the reaffirmation agreement, select bankruptcy, claim actions, and search for reaffirmation agreement. There is also an official form for the cover sheet. It'll be Form 427. And if the cover sheet needs to be filed separately, select bankruptcy, claim actions, and search for reaffirmation agreement cover sheet. Okay, so let's review to see if we have any questions. Okay, I do not see any questions at this moment, so I will go ahead and hand things over to Katie to discuss online ECF training. Oh, sorry, 1 second, we do have a question. Are proof of claims and reaffirmations filed by creditors without being a registered filer? To answer that, so we do receive proof of claims and reaffirmations through the mail by people who are not registered with our court. So you are able to send it that way. Does anyone else want to add to that though?
I think you covered it.
Okay. All right, Katie.
Thank you, Alexis. As Alexis stated, I'm going to go over some online ECF training. And we provide the training to file electronically for new staff members, as well as a refresher session for current staff. If you're interested, feel free to give us a call at either office. However, our amazing trainers, Summer and Alexis, are located in our Gulfport office, and you can call our main line and ask for them. They're ready to assist and ensure you get the support you need. I do see that we have a leftover question. It says, what happens if the debtor defaults on a payment in the reaffirmation agreement? Does the debt automatically become part of the bankruptcy case again? That, I'm sorry, is a legal question, and I cannot answer that. I'm not an attorney, so. Okay. We are bringing our seminar to an end. We're getting you out of here about an hour and a half early. I hope no one's upset about that. Y'all are our guinea pig on this new approach to giving this seminar, as this is our first one we've done via Zoom. We all want to thank you for participating in today's seminar. The PowerPoint presentation will be posted on our home page, not under the resource tab, but it's going to be on the home page of our website, and a recording of the webinar will be available on the YouTube page. We hope you found the content valuable and enjoyed our new approach. If you have any questions or need further assistance, please do not hesitate to reach out to us, or if y'all even think of other questions that you didn't think of during the seminar, please reach out to us. You have our phone numbers and emails probably. Send it away. And we appreciate your time and look forward to connecting to you again soon. Oh, I have one more question. How do you listen to audio files? Are you talking about this webinar or a different type of audio file? When the court docket shows an audio file. I am not 100% sure on that. I'm not sure if we have ever had one but I can get that information and get it back to you. I see that you asked anonymously, but I'm going to give you my email address. If you will send that to me, and we can get that answered to you, okay? Can a creditor register for a limited filer? A creditor is considered a limited filer. The reason why we call it a limited filer is because they have limitations on what they can file. Therefore, it's called limited filer. If you are interested in becoming an electronic filer as a limited filer, you can give us a call, and Summer and Alexis will get you trained, and you'll be able to file online.
And Katie, there is information in the Attorney ECF docketing guide for audio recordings.
Oh, thank you.
You're welcome.
I see that there was an anonymous that I would like to know that information. Well, I'm guessing that's about the audio. But as Cynthia said, it is in in our docketing guide. So if you want to go look on our website in the docketing guide and search audio, it should be able to tell you. Or if you want to give us a call, we can find that out for you. I'm going to go ahead and give you your my direct line. If any of y'all want to call, my number is 228-563-1796. Because some of these are questions being asked anonymously, and we're not sure who's asking, so we don't know who to get back with. Okay? All righty. I think we're going to go ahead and end the seminar. Thank you again. And if we did not answer your question, please reach out to us and we will get that answered for you. Hope y'all have a great day. The remainder of your day is great. Sorry.